another murder case, and I am going to discuss about this murder case. And this lecture or with this case, about this case, I hope that it is very helpful for any lawyers or law students who are practicing in regular in lower court and high court divisions in the criminal side. Actually, benefit of doubt. Number one, corroborated witness. Number two, independent witness. Being guilty, any person who is convicted of a crime arising the allegations against the accused petitioners, it will be relevant or not because submitted relevant documents are produced before the court. The court decides and analyzes the recovery documents and witness. It will be find out being guilty the accused petitioners who who are connecting in the case. But allegations against the any person, but there is no authentic or strong evidence, never possible submitting before the court by the prosecutions. When the creations doubt and this case will be going to be weak case or weak evidence. Actually, creations or arising allegations, it will be strong when submitting relevant documents for the purpose of the case because never decided and the person is the accused person is guilty or punishable according to procedure. And number two, independent witness supporting the relevant documents and when happened the offense by the accused and co-accused are connected with him doing act at the place of occurrence because investigation officer completed the investigation and sent the charge police report before a court and accepting cognizance and by the honorable court and transmit was transmit this case record was transmit to the trial court and trial court accepted and framing charge by framing charge that started trial. What is trial and how to complete the trial matter in trial court, and I am going to discuss about some thought of trial. After starting trial in trial court, started sent to summons to the witness or investigation officer or forensic expert, and they are coming before the court as a witness and giving that their statement, then completed statement of the witness, then defense lawyer, accused, appointed by the accused, then he started cross examinations, given statement by the prosecution witness, and submitting relevant documents before the court, and there is options on behalf of the accused petitioners under section 342 the code of the criminal procedure. But there is chance to say he is not guilty for the purpose of the case and bringing allegation against him is not relevant. There is the chance to say or statement it will be granted before our court. Acceptable statement of the accused petitioner according to section 342 of the code of the criminal procedure, because that called in Shafai Shakhi in Bengali or Bangla. And Shafai Shakhi, this is under section 342, there is the chance, and given the oral statement which is relevant before the court can decide and acceptance his statement, and the accused has options to corroborate it, to submit, to get pay for submit the corroborated witness which is relevant for the purpose of the case, and given by the corroborated witness, and it will be preferred on behalf of the accused petitioners, and options on behalf of the accused petitioners submit or mentions the name of the witness, but otherwise without knowing, and it will be effected on the case or in the case on in positive or negative, then to mention this name of the witness on behalf of the accused petitioners. Otherwise it will be burden of proof or it will be effected in negative, and the accused petitioners will be harmful for getting the remedy before honorable court and getting the justice before honorable court. Actually, the trial court maintain the procedure and to analyze the evidence, recovery, alamat uddar, and which is the preferable for the purpose of the case, and arising the allegations against the person who is the accused or co-accused, but creations doubt for the purpose of the case according to benefit of doubt. This is the positive side on behalf of the accused petitioner, because prosecution's burden of proof under section 101 of the Evidence Act, and there is no chance or options to deny the submitting relevant documents which is the connected with the case against the accused petitioners, and by using to identify the allegations and being guilty the accused petitioner for the purpose of the case. Hello viewers, I am Advocate Sharon Kumar Rai, Supreme Court of Bangladesh. and I am regular practitioner in High Court divisions and for the purpose of the criminal side. And with I believe that and read the more study and about constitutional law and civil matter. Thank you very much. And thank you everyone who are joining with me and live sessions and watching and listening me is with me. Thank you very much and get your support. With your support, I hope that I can do better in my life than past. Thank you very much. Eyewitness, it is very necessary, not mandatory, because except eyewitness on the basis of the circumstantial evidence, the trial court can be guilty the accused for the purpose of the allegations, with the allegations which is the arise by the prosecutions. Number 2, independent witness. It will be effected and to change the punishment against the accused petitioner, and it will be applicable by the honorable court. And all evidence, actually circumstantial evidence, independent evidence, and given by the accused petitioners under section 342 Shapai Shakhi, and the accused can mention the important name who can be witness for the purpose of the case. The accused petitioners have to maintain the mentioning the name they are connected with the case and they are getting the information clearly, relevant information about the case, when it will be effective, when it will be mentioned before the court, otherwise never mentions the name, because that statement of the witness, it will be effect in negative thought or positive thought. Because without specific allegations and arising allegations against the accused but not submitting relevant documents, and there the presence of the eyewitness about the case, it will be not clear or mentioned by the prosecutions, and court decide that there is the creations and not submitting the relevant documents by the prosecutions, because this case is weak and recovery documents prefer the case, and forensic expert and his statement or as a witness, this statement, it is preferable with the case or not, and medical report when happened the occurrence or offense by the accused and distance, the time, durations of time, and after doing the act or offense, when the police officer arrested the accused, and time, occurrence of date of occurrence, and act happened, time, those are very important part, important score for the purpose of the case, and it will be identified and specified, and bringing allegations and connected with the case, and provided that recovery documents provided that there is the similar of the case, and mentions the offense, durations and time, and at the place of occurrence, and under section 161 the police officer accept the statement of the witness which is preferable and with the case, and to support being guilty the accused petitioner for the purpose of the crime. This is very important score, because prosecution's liability and bound to submit relevant documents getting the remedy on behalf of the victim, because court analysis with the documents. Please never call when I am connected with live session, because it will be very disturbed and there is chance to disconnect from live session. Thank you very much. And not necessary and unnecessarily never call and when or join or starting my live session. Thank you very much. Prabhat Roy, thank you. This is the most important role, and the victim can demand the justice before the court and demand being guilty the accused petitioner for the purpose of the case, but prosecution's liability and how to identify specific allegations with relevant documents submitted before the court, and there is the eyewitness, it will be submitted, and statement is necessary, and we connect the case and find out the independent witness are most important to submit or connect it with the case, because prosecutions demand justice on behalf of the victim but fail to submit relevant documents against the accused petitioners, because there is no specific allegations how to find by the accused by the before the court and with relevant documents, because analyzes the relevant documents and be connected with the case. When it will be possible by the court deciding the judgment and order, pass judgment and order, and being guilty the accused petitioner to I am so sorry, and drop me my, and this is very urgency matter, so I am so sorry and we join with you. Pass the conviction, death sentence the accused petitioners with fine against the accused petitioner, first time there is important role to identify and relevant documents which is submitted before our court by the prosecutions, because prosecutions has liability to submit and query document before honorable court. There is no options to deny and avoid the submitting relevant documents, because without submitting relevant documents not find out being guilty the accused petitioner. And from my experience and little time, I feel that I am criminal trialer. I was criminal trialer in Dhaka Judge Court, and from my little experience, and there is no eyewitness but being guilty the accused petitioners by the court, because submitting circumstantial evidence and preferred that identified the guilty mind of the accused petitioners, who is connected directly act done by himself. And this lecture will be helpful for that person who being or be advocate or law student practicing regular in lower court or high court divisions in the criminal side, and being advocate feel that being a criminal trial lawyer in life. I hope that my lecture will be little support and to change your thought of the criminal mindset, because how to collect and the evidence and how to submit when the submit relevant documents, which is very essential for the purpose of the case, because prosecutions laws FIR in Thana against the accused petitioners, and accused petitioners act done by the case, but same time at the place of offense it is identified very necessary, and it will be more score added on behalf of the prosecutions and get the justice before honorable court, and being guilty the accused petitioner against and being guilty the accused petitioner. I hope that trial court always be careful, decide that and pass judgment and order, and being guilty the accused petitioners for the purpose of the death sentence, because with permission section 342 374 the code of the criminal procedure before high court division. I hope that the classified of the evidence, eyewitness, number 2 independent witness, number 3 circumstantial evidence, number 4 corroborative evidence or witness, who or they was or were important and to effect to decide about the case and for the purpose of the punishment. Actually, in the criminal side, murder case section 302, 34, 201, very important part or important ingredients of the sections, it will be identified at the first time. Otherwise, being guilty the person in the criminal before the trial court, it will be relevant or not identified and the accused petitioners, convicting the accused petitioners, has right to applications for apply or applications jail appeal before High Court divisions. More cases convicted the accused petitioners, but applications for jail appeal, then the High Court divisions accept that and set aside the judgment, set aside the passing order by the trial court. Strong evidence provide that, and allegations being specified or be specified, most important score, and the person who are connected with the case, involving with the case, or falsely implicated in the case, because sometimes from our experience, my experience, for the purpose of the personal intention, falsely implicated in the case, like murder case and another case. But I am going to discuss about section 302 and common intentions 34. And this is, I hope that some words, read with some words. I hope that you enjoy with me and by reading this para. While considering dying declarations, and is required to see whether the victim had the physical capability of making such a declaration, while witness who had heard the deceased making such statement heard in it correctly, whether they reproduce name of the assaultant correctly, and whether the maker of the declarations had an opportunity to recognize the assailants. Actually, given the declarations, dying declarations by the victim, to which person, who is the person, or this person has bad intention against the accused, previously it will be identified to necessary for the purpose of the case. Victim given the dying declaration to the person, but the person who has the previously enmity against the accused, and this person or that person getting the dying declarations from the victim with submitted specific time and place of occurrence, very necessary. When this dying declaration will be relevant and use against the accused petitioner. But another person saying that before the court, the victims given dying declarations to him that is not connected with the case, and it will be acceptable when and produce the dying declarations with the relevant documents. Another person knows that he was present with me, or he still with me, or any other collect document produced before honorable court, otherwise never granted as a dying declarations and used against the accused petition being guilty, the accused for the purpose of the case, because before being the guilty the accused, the honorable court, trial court has to maintain and according to procedure and to analyze the witness which is submitted by the prosecutions, and these documents, submitting documents with connected with the case or not, because innocent cannot be guilty by the trial court, because this is the fundamental rights, article 27 of the constitutions. Every person equal, and we know that the article 27 of the constitution or constitutional law, there is two concepts: English concept or thought, British concept or thought, or another concept, American concept. British concept first time in negative, number 1, equality before law, and number 2, American concept, protection before law. Equality before law, all persons are not equal getting the remedy or justice before the court, because there is the classification of nature and any other effected to classify the person, but protections of law, but before law, American thoughts provide that every person is equal, demanding the justice before honorable court. This is the American thought, and this is the another English thought. I hope that my lecture will be helpful for you. Murder case, this is the serious nature, gravity of nature, and section 320 grievous hurt, penal code 1868 elements of this section, and seizure list section 103 CRPC and 27 of Evidence Act, and recovering the documents by the inspector or IO or investigation officer, or which is the relevant, and medical reports supporting the fact of the case, or forensic report or forensic expert given the statement before the court which is the relevant, and to submit or to support the case that being guilty the accused petitioner before court, and being guilty or convicted the accused petitioner gets sentence, and which able that to fine 1,000, 10,000. It will be choiceable as usual the punishment or demanding of the witness. Thank you, Sujata. Thank you. Because I hope that, and studying the criminal case about 302, 34 of penal code, And this ingredient is very important for the purpose of the case, because being guilty, the person who is the accused or connected with the case, then identify this person is the guilty for the purpose of the case. I hope that, and this topic about murder case, section 302 and 34 of penal code, and next time I will come back on live sessions and try to share about murder case, another murder case, sensible murder case, and I feel that I am criminal lawyer and I am regular practice in High Court divisions, and I feel that I was being trial lawyer in Dhaka Judge Court, and from my little experience and ingredients of this section supporting the case, pre-plan knowledge, intention, and act done by the offense, the accused will be benefited. It will be identified very necessary. Otherwise, converting the punishment, section 304, punishment called for homicide of penal code. I hope that section 304, punishment of culpable homicide, there are two types of punishment, with intention and no intention. With intention, lifetime imprisonment or 10 years or fine, and no intention, imprisonment 10 years or fine. And this topic under section 302 murder case, and with 34 common intention. And thank you very much, and stay with me and watching and listening me, and I hope that to support me, and with your support next time I try to my best and come back with you with new lecture, new topic, any other topic. It will be related murder case or constitutional or civil matter. It will be, I hope that. And thank you very much, and thank you to everyone, and to viewers, all viewers, and who are connected with me and support me. And if you any questions, my lecture will be clear or not, please send your message or write your feel in comments. I hope that to solve your questions, and next time I do better, and next week, next lecture. Thank you very much. Thank you. Namaskar.